Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Max Academy for Excellence vs Commissioner of Income Tax, Exemption, pronounced by Chennai Tribunal on 7 May 2026. The appellant trust, Max Academy for Excellence, was registered under the Trust Act in 1993 with the objective of imparting skill and personality training to students. It had original registration under Section 12A from 29 January 1997, renewed up to 31 December 2021. On 15 July 2025, it applied in Form 10AB for renewal under Section 12AB and also sought approval under Section 80G(5). The CIT rejected both applications vide orders dated 28 March 2026. The CIT concluded that the trust's activities were not education, as defined in Sole Trustee, Lokashikshana Trust vs CIT 1975-101 ITR 234, and noted that no voluntary contributions were received in the preceding 3 financial years. The CIT inferred that the activities were not genuine. The Assessee appealed to the ITAT on grounds that the CIT erroneously invoked the Proviso to Section 2(15), ignored settled precedents, and failed to consider CBDT Circulars No. 11/2008 and No. 1/2009. The trust contended that its activities were charitable under the General Public Utility (LIM). The ITAT held that even if the trust's skill and personality training did not strictly fall under education, it undoubtedly fell under advancement of any other object of general public utility in Section 2(15). The trust charged only nominal fees to recover costs, which does not render the activity commercial. The ITAT emphasized that mere receipt of nominal fee to recover expenses does not amount to commercial activity. The dominant object of the trust was charitable, and incidental income from fees does not change its character. This principle was fortified by citing 4 landmark decisions. The ITAT relied on Institute of Chartered Accountants of India vs DGIT, E. 347 ITR 99, Delhi, Bureau of Indian Standards vs DGIT, E. 358 ITR 78, Delhi, CIT vs Lucknow Development Authority, 219 Taxman 162, Allahabad, and Sabarmati Ashram Gaushala Trust vs ADIT, 25 ITR 70, Ahmedabad Tribunal. These cases consistently hold that nominal fees do not make a charitable activity commercial. The ITAT found no material on record to support the CIT's conclusion that the trust's activities were not genuine. The trust had provided skill and personality training to students in government schools in Tamil Nadu and Andhra Pradesh at nominal fees. Absence of voluntary donations does not imply non-genuineness. Since the denial of approval under Section 80G(5) was solely based on rejection of 12AB registration, the ITAT applied the same reasoning. Upon directing grant of 12AB registration, it also directed the CIT to approve the trust under Section 80G(5) from the date of application. The 2 provisions are interlinked. The ITAT allowed the appeals and directed the CIT to grant registration under Section 12AB and approval under Section 80G(5) from the date of application. The tribunal reinforced that skill development at nominal fees qualifies as charitable purpose under general public utility, and the proviso to Section 2(15) applies only when there is profit motive. Question: what is the key takeaway from this ITAT ruling? Answer: the ITAT held that providing skill and personality training at nominal fees qualifies as a charitable purpose under general public utility in Section 2(15). Mere receipt of fees does not make the activity commercial, and the CITE cannot deny registration without material evidence of non-genuineness. Question: which High Court decisions were relied upon by the ITAT? Answer: the tribunal relied on Institute of Chartered Accountants of India vs DGIT, Delhi High Court, Bureau of Indian Standards vs DGIT, Delhi High Court, CIT vs Lucknow Development Authority, Allahabad High Court, and Sabarmati Ashram Gaushala Trust vs ADIT, Ahmedabad ITAT. Question: what is the significance of the CBDT circulars cited by the Assessee? Answer: the Assessee referred to CBDT Circular No. 11/2008 and No. 1/2009, which clarify that activities in the nature of training or skill development can be considered charitable even if fees are charged, provided the dominant object is not profit. The ITAT's reasoning aligns with these circulars. Question: will this order apply to other trusts seeking ATG approval? Answer: yes. The ITAT's reasoning that a valid 12AB registration is a prerequisite for ATG 5 approval and that both must be granted consistently will guide future assessment orders by the CITE. Question: does this decision affect the Proviso to Section 2(15)? Answer: yes. The ITAT implicitly held that the Proviso, which excludes trade, commerce, or business, is not triggered where fees are nominal and cost recovery based. The trust's activities remain charitable under the General Public Utility head. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, TaxPundit.org. If you have any questions, feel free to write to us at TaxPundit@taxpundit.org or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.